Okay, are we ready? All right. Good morning, everyone. Welcome to the Board of Adjustment meeting. We're glad everyone could be with us today. Just a housekeeping note before we get started. If you could turn your phone to either, if you can turn it off or put it on silent or vibrate, that'd be real helpful. Going off in the middle of testimony is, sometimes is distracting when we're in the proceeding. So with that said, we're happy everyone is with us. This meeting of the Escambia County Board of Adjustment for September the 18th, 2024 is hereby called to order with 4 members present. And before we get started with our case, we have a housekeeping matter. As you know, we need to elect a vice chairman for the board. And so at this point, I think it would probably be best that we go ahead and resolve that issue before we move into our case that we're going to hear this morning, if that's agreeable with the board.
It is, and Mr. Chairman, I'll make a move, and I haven't discussed it with Marty. I'll make a move that Marty be the vice chair.
I have a nomination. Do I have a second?
Yes, sir.
We have a second. All those in favor of Mr. Shack becoming our vice chairman, please raise your right hand. Let the record reflect. Marty, welcome to this pinnacle of power. You've achieved it. So we certainly appreciate Marty's willingness to serve. Now we move into our proceeding that is before us. Would the clerk please swear in the members of the staff?
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you.
All right. Let the record reflect that all staff members replied in the affirmative. Members of the board, copies of the staff's resumes have previously been provided and remain on file for reference. The board has previously recognized our staff as expert witnesses. Does anyone have any questions regarding their qualifications and abilities to offer expert testimony? Seeing none. The BOA meeting package for September the 18th, 2024, with the Development Services staff findings of fact, has previously been provided to board members. The chair will now entertain a motion to accept the BOA meeting package into evidence. Do I have a motion? I have a motion. Do I have a second?
Second.
I have a motion and a second. All those in favor of accepting the BOA meeting package into evidence, please raise your right hand. Let the record reflect this motion passed unanimously. We now turn to the issue of proof of publication. Do we have proof of publication, Madam Clerk?
Yes, sir.
Did that publication meet all the legal requirements?
Yes, sir.
The chair will now entertain a motion to waive the reading of the legal advertisement. Do I have a motion? I'd have a motion. Do I have a second?
Second.
I do have a second. All those in favor of waiving the reading of the legal advertisement, please raise your right hand. Let the record reflect that this motion passed unanimously. Members of the board, have you reviewed the minutes for the Board of Adjustment meeting held on August the 21st, 2024? Upon your review of these minutes, are there any additions, corrections, deletions that you wish to make? Let the record reflect none or no member raised such a objection. The board will now entertain a motion regarding the minutes for the Board of Adjustment meeting held on August the 21st, 2024. Do we have a motion?
Motion.
We have a motion. Do we have a second?
Second.
We do have a second. All those in favor, please raise your right hand. We now turn to the purpose of the Board of Adjustment and the conduct of the meeting this morning.
The Board of Adjustment hears administrative appeals, variances, and conditional use requests. These hearings are quasi-judicial in nature. Quasi-judicial hearings are like evidentiary hearings in a court of law, however less formal. All public testimony will be taken under oath, and anyone testifying before the BOA may be subject to cross-examination. All documents and exhibits that the BOA considers are entered into evidence and made part of the record. The giving of opinion testimony will be limited to experts, and closing arguments will be limited to the evidence in the record. After hearing the testimony and arguments for and against the proposed action, and before making its decision, the BOA will consider the relevant testimony, the exhibits entered into evidence, and the applicable law. Because decisions of the BOA relating to variances, conditional uses, and extensions of development order for site plan approval are final, unless overturned by a court of competent jurisdiction, the county may issue development orders and permits for properties in accordance with the decisions of the BOA. However, if applicant requests the issuance of any such order or permit, and such order or permit is issued, the applicant and not the county shall bear any risk that such decisions may be set aside. The development order or permit may be revoked, or the development may be otherwise enjoined by the reviewing court. Any applicant for relief from a decision of the BOA for said actions, or any aggrieved party as defined by state law, may seek review of such a decision by filing an appropriate pleading in a court of competent jurisdiction within 30 days of the BOA decision. The date of the BOA decision shall be the date the BOA voted at the conclusion of the hearing. Whenever the BOA denies an application, no new application for an identical action on the same parcel shall be accepted for consideration within a period of 180 days of the BOA decision. Any person aggrieved by a decision of the BOA relating to an appeal of an administrative decision may, within 15 days thereafter, apply to the circuit court for review. Each individual who wishes to address the board regarding a particular issue must complete a blue request to speak form and submit it to the clerk of board. These forms are located on the table at the back of the commission chambers. You will not be allowed to speak until we receive one of these completed request to speak forms. We must have these completed forms for public record.
Thank you. We now turn to the matter of ex parte communications. All written or oral communication outside of this hearing with members of the BOA regarding matters under review today are considered ex parte communications. Ex parte communications are presumed prejudicial under Florida law and must be disclosed as provided in Board of County Commissioners Resolution 9613 before a decision by this board on any administrative appeal, variance, or conditional use request. The chair would ask, as each case is heard, that any board member who has been involved in any ex parte communication regarding the respective issue to please identify themselves and to describe this particular communication. We now turn to the single case we have on the docket this morning. This is case number CU 2024-16. The address is 5190 Mobile Highway. The request is to allow a restaurant not among permitted uses. This has been requested by Wilson Pinho and Leonardo Morales, agents for Fernando Chavez and Ruben Chavez, owners. Before we ask the applicant to come before us, I need to ask, has there been any ex parte communications regarding this case? Let the record reflect none. Knowledge or information obtained from a site visit or other sources? Let the record reflect none. Does any board member intend to refrain from voting due to a voting conflict of interest? Seeing none. Would the individuals who are party to this item please come to the podium, state your name and address for the record so that you can be sworn in by the clerk. All right. Good morning, sir. We're
Good
glad to
morning.
have you with us.
I'm glad to be here too. My name is Wilson Pinho.
All right. Would you face our clerk?
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, that's right.
Thank you. And Mr. Pinhill, will you state your address for the record?
5190 Mobile, my home address, or?
You can, whichever address you'd like on the record.
5190 Mobile Highway, Pensacola, Florida, 32526.
Well, good morning, sir. And were you provided with a copy of the criteria required to obtain a conditional use and a copy of the staff's findings of fact?
Yes, I did. I was.
And you have read those documents, I
Yes, I
presume? All right, sir. And you understand that all the criteria must be met in order for the board to grant
Yes, I
this requested conditional use.
Yes, I do.
Okay. At this point, if you would like to make an opening statement, we would be very happy to hear it. Or if you prefer, the staff will make its findings of fact, put them on the record, and then you might follow up with any additional comments that you would like to make. It's entirely up to you how you would
Yeah, I
like to
prefer the
proceed.
staff to,
You would like the staff to?
yes, please.
Okay, all right. Well, we'll ask the staff to make their presentation and then ask you to stand by for what additional comments and also board questions if there are.
Sounds good.
All right, thank you, sir.
Thank you.
This is my name is Christina Smith, an urban planner. This is the conditional use case 2024-16. This is the location map for the property on Mobile Highway. Here is a 500-foot radius zoning map showing the parcel is split zoning with commercial in the front and HDMU in the back with all the improvements in the commercial part. This is a future land use map. This is the aerial map for the property. This is a public hearing sign posted on Mobile Highway. This is looking south along Mobile Highway. Now this one's looking north. Those may be backwards. Yeah, and then this is looking east on the subject property from Mobile Highway. This is looking onto the proposed patio. This is a public hearing sign posted on Charbor. This is looking east along Charbor. This is looking west along Charbor Drive. And that concludes the photography. Now to the staff findings. This is for the applicant is seeking a conditional use approval to allow a restaurant that is not along the permitted uses in the commercial zoning district. So the whole purpose of this is just for that outdoor seating on the front. The restaurant's allowed in it. The alcohol consumption is allowed in the building because we did a site inspection. It's not within 1,000 feet of a school, church, daycare. So this is just for that patio, to have a restaurant there. So for criteria A, the proposed conditional use of outdoor seating, outdoor patio dining can be conducted and operated in a manner that is compatible with the adjacent properties and other properties in the immediate area. The patio addition is to the front of the building, which fronts Mobile Highway. The site is located along Mobile Highway, a principal arterial roadway, and along Charbor Drive, a local street. The parcel has split zoning with all improvements in the commercial zoning portion of the property. The northeast portion of the property is owned HDMU with the power line easement and is otherwise undeveloped. The building has historically been operated as a restaurant. A development order was approved for Monterey's Mexican Grill restaurant in 2000. This parcel is bounded on 3 sides by right-of-way. The northwest side of the property has a power easement and is adjacent to vacant commercial and 1 residential lot at the northwest of the property. There are residential uses in the subdivision on the other side of Charbel Drive. For finding criteria B, the applicant will use existing utilities as necessary to continue the operation of a restaurant. Criteria C, ingress and egress will be accessible through existing driveway connections to Mobile Highway and Charbor Drive. Criteria D, outdoor seating areas are shown on the proposed site plan. Provisions of the Land Development Code does not allow the making of any noise or sound that exceeds the limits outlined in LDC or the county noise ordinances. In addition, air pollutants, glare, vibrations, and other nuisance hazards are addressed by the LDC and must be met. For criteria E, solid waste must be provided on the site. All on-site waste containers will be appropriately located and screened from off-site visibility. Criteria F, the subject property abuts 1 single-family dwelling which already has a large natural vegetated buffer along with power lines. Criteria G, signing and lighting would be evaluated during the land development review process and must be limited to what is allowed by provisions of the LDC. Exterior lighting should be deflected from adjoining properties and public streets. Criteria H, the location was approved as a restaurant in 2000 but has been vacant for a few years. The location appears adequate for the scale of the proposed use and the specific county requirements for this type of operation. And for the last criteria, the parcel is zoned commercial and HDMU, which allows for restaurants, including on-premise consumption of alcoholic beverages. The existing buildings, in addition, are located within the commercial zoning district. Staff recommends approval of the proposed use as requested.
Okay. Excuse me, I have to sneeze. Oh, yeah, that's better. Sir, can you come back up? I'm sure that. Could you tell us exactly what you plan to do with your this addition?
Just have outdoor seating.
Well, I'm sorry, sir.
just have an outdoor seating area and serve food and drinks for
And,
customers.
and so you would be serving alcohol?
We'll be serving alcohol.
And would you have music?
Just the
bands,
ambience
that sort?
music.
I'm sorry,
Just
sir?
the ambience music, like the restaurant has speakers.
Oh, okay. What about live music, anything like that?
It's not on as planned right now. If we do in the future, it should be like just single musician playing or something like that. But it hasn't been on the plans yet.
All right, sir. Board members, I jumped the gun. Does the board have some questions?
This is of staff, how near is any church or elementary school?
We did a site inspection on this visit, and it's over 1,000 feet from the nearest church. There's no schools anywhere nearby or daycare. The closest was a church north on Mobile Highway.
Do you know how much over the 1,000 feet?
I think it may have been like,
1,200, 1,100?
I think it was like over 1,200 over there.
Was the measurement done from the patio, which we're discussing? if
It was
I
done
understand?
from the front door, which is further in than the patio, but not by much, maybe 10 feet or something, if that.
Would you pull up the photograph of the front of the building again, please? And what we're looking at is where the outdoor dining would be,
Yes.
so it's an existing structure.
Actually, we built that one. It wasn't the when was old Monterey's. We built that on the side.
Approximately how many seats would be available in that area?
We guessing about 40 seats.
And what are your operating hours?
11 a.m. to 10 p.m. Monday to Sunday to Thursday, and Friday and Saturday 11 a.m. to 11 p.m.
Staff, are there noise ordinances for this kind of operation?
Yes, there's the county Caleb McCarty, AICP, Escambia County. There's the county noise ordinance. Typically, in a situation such as this, as far as a generation of noise, it would arise from some type of code enforcement complaint. We've seen that a lot, from various operations for whatever reason. Code enforcement initiates an investigation and sees exactly what's going on, whether it's the weekend and those type of things, and the applicant would then work with county staff to come into compliance. Yeah. Yes, sir.
And the issue here is if I understand what the question before us is, the patio, the outside service of food and drink is the issue that we're being considered. Is that right?
Yes, sir, Mr. Chairman, I can answer that. So the property, as you saw from the zoning map, and as Ms. Christina showed in her findings, it's commercial zone property with HDMU in the back. So with the primary use of the property is on the commercial zone piece. It's an allowed use, restaurants are, and those type of activity. But the primary intent of the commercial zoning district, everything must be indoors. So once there's a use such as an alcohol license that triggers or serving of an outdoor type of use, then it triggers a different review. And we have determined that restaurants not otherwise permitted and the conditional uses of the commercial would satisfy that. It's kind of what we deal with our food trucks, treat it somewhat similar in nature to those, like our food truck park type.
Are there homes, looking at this map, right across the street, are those single-family homes?
So down Charbor Drive, or road, is it Drive? Drive, there's homes behind it. I think over on this side here, I think those are duplexes, if I remember right, should be. Did I think
Or
they-
they're, in other words, they're
Apartments.
residential quarters.
Yeah, like multifamily.
And I take it the white building is the building we're discussing, right?
Yeah, well, it's got a red rooftop.
Well, the red roof, yes, yeah.
And so, I believe the applicant, it may be in the backup, did provide, the site plan from the previous addition. The addition actually, goes towards Mobile Highway.
It's in the very front.
So the, you know, potential conflicting use, well, here would be, I guess, less impactful, as otherwise being on the back of the building or the side towards the residential neighborhood.
Oh, yeah, yeah. It's kind of-
Board, do we have any other questions about this? All right, seeing none right now, we do have one speaker in addition to you, sir. So if you want to just hang on a second,
of course.
we'll hear from Mr. William Jones.
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Please state your name and address.
William Jones, 2123 Pullman Circle, Pensacola, 32526.
Yes, sir. And what would you like to tell the board about this application?
Well, on the surface, I would say welcome to the neighborhood. It's good to see life in the building again, and I can see where it could be a huge asset to the neighborhood. But I just have a few questions. The permitting process was kind of strange on this because early on this wasn't pursued in the normal paperwork. And then last month, there was a no-show, from people. But in the meantime, they've had a soft opening, and they're doing good. Everything looks perfect, but when things are delayed like they were and, approach it in that way, then it makes you kind of take a closer look. The parking lot is set up for 96 vehicles in that neighborhood. 2 to a car would put about 200 people in the restaurant, which would be normal. But they've moved in blocking in the back parking lot for 2 more areas, which would bring around 288 vehicles or 550 plus people to the restaurant. That, to me, may be a problem. And I'm just making sure that we're just not going to have any major blowout parties over the weekend and stuff that interferes. We had the Blue Bar down on Mobile Highway a block away, and after the second murder from over intoxication, they finally shut it down. And we just want to make sure this isn't going to open up in the neighborhood. We've done a lot of work in the neighborhood, and we finally have our property values approaching the 300,000 mark, and we don't want anything to come in and crash that for us. That's my only concern, is just to make sure that everything's, going to be normal, and an asset to the neighborhood and not a problem. That's all I have to say.
Has food and drink being served outside now?
I haven't seen any.
Okay.
Everything's normal, everything's quiet. People are, it's a little extra traffic, but that comes with anything. And I don't really see that being an issue. And if it becomes an issue, then we'll just have to approach the state, to put in lights or something to help out. Shouldn't be an issue.
All right, sir.
I have
Thank
a
you.
question for staff. I understand your calculations with the parking spaces. But isn't there is there an occupancy limit or rules as to how many people can be in the building at any one time?
Yes, that's going to be dictated by the building code and the fire code. These folks in the restaurant industry, they should know. I don't know the top of my head, but yes, there is occupancy limits of how many people in the building, how many people on the patio. The applicable parking, the comment there from staff would be, you know, if there are proposals to expand the parking per se, you know, those things require development review. So the applicant would need to come and speak with county staff. You know, there's limitations, there's excess from county regulations concerning parking. So I would just, you know, the applicant would need to work with us for any type of compliance on that. Yep.
Is this going to be just a sit-down restaurant where you order alcoholic beverages and consume them there, or will it be a takeout?
It will be takeout as well, but definitely
So-
Come on up.
we will sell mainly seating for customers that's coming dining, but we will also sell takeout food.
Okay. And of course, the whole reason that we're here is because you plan to offer alcoholic beverages outside in your patio area for,
Not outside, in the patio area.
yeah,
Yes.
that's what I mean.
Uh-huh.
All right, sir.
And Mr. Godwin, that's essentially what triggered this process, is the alcohol license types. When the state requires us to, you know, the county as the zoning authority to sign off on different license types, and that's when we go through our processes, looking at schools, churches. This particular license type, they already have a alcohol license to serve indoors, and that's allowed by the zoning. This particular license allows for outside type of serving, you know, patio type of serving. That's what triggered essentially why we're here today, is we couldn't say that outside uses were allowed with that different license type, which put us here.
Well, what assurances do we have about outside, you know, inside service is one thing, outside service is an entirely different thing. You've got a nuisance potential that is inherent, I would think, in that sort of thing where alcohol is involved and music and that sort of thing. What gives the county staff comfort that this will not create a nuisance for the neighborhood? Because you do have some homes of dwellings of various family dwellings, and they're not that far away.
Sure, absolutely. So the patio is constructed, and again, the patio is in a way that, yes, the building is closer to the entrance of the neighborhood. Obviously, if the building was in a totally different spot, then it may be more conducive. But the patio is in a place that would potentially have less of an impact as being shown. Again, we do have an active code enforcement office, and it's good to see the citizen participation. I'm sure if there's anything that would get out of hand or got into, you know, the realm of needing review with county noise ordinances or nuisance, then, you know, again, we would be complaint driven, but that's when that would open up to any type of complaint. So that's kind of how that goes down.
Can I say something here? Just to put an idea in your head, I would compare this to Beef O'Brady's. It's a sports bar with the TVs and serving inside. So, I mean, that's basically what you're looking at. The noise, of course, I live right behind here, so we have to put up with 9 Mile Billiards and Woodsy's Bar. But now, I've got to say, since the pool hall opened up, I've called them one time about the noise, and it immediately stopped. And in 38 years, I've called Woodsy's twice. And the management, they stay on top of things, and I would expect the same, you know, with this. I mean, I'm not really concerned about the noise and stuff. I'm just making sure we're not having mega parties in the neighborhood, you know,
Alright.
things along that sort. But, as a resident in the neighborhood, I'd have to say at this point, I feel comfortable with what's going on.
All right, sir. Board members, do we have any final questions?
I have one more. Regarding the use of the space for other than normal restaurant use, would this building be used for parties, rentals, things like that?
No, our main license is for a restaurant, that's what we're gonna keep on.
Thank you.
Thank you.
Sir, thank you very much. We appreciate your presentation. We appreciate hearing from Mr. Wilson also. Board members, do we have any discussion about this? Seeing none, we've reached the point then that we need to make a decision about this application. Do I hear a motion?
Mr. Chairman, I move that we accept staff's findings of fact and grant this conditional use request.
We have a motion by Mr. Smith to grant the application. Do I have a second?
Second?
We have a second from the vice chairman. All those in favor of granting this application pursuant to the findings of fact as presented to us by the staff and the testimony of the applicant, please raise your right hand. Let the record reflect that this application was approved unanimously. Thank you, sir. We appreciate you being with us today. Board members, since we only have one today, Ms. Rachel, we have any coming attractions?
Yes, we do have one conditional use next month.
Oh, my goodness. Okay. Well, I appreciate everyone being here as usual, and everyone have a good month, and we'll do this again. Thank you. Yes, meeting adjourned.